seated.
Good afternoon. The case on the docket this afternoon is Costanza against Caldwell. And we ready?
Madam Chief Justice and Justices, may it please the Court, my name is Kyle Duncan. I represent the appellants in this matter. I'd like to reserve 5 minutes for rebuttal.
Can you speak a little louder, or will that mic go up higher?
I think if you just lean into it a little bit more.
Sorry about that.
Okay.
How's that?
That's better.
Great. Kyle Duncan for the appellants. I'd like to reserve 5 minutes for rebuttal. I'd like to begin, Your Honors, by anticipating a question that I think may be on the Justice's mind, which is why decide this issue at all, since the Supreme Court of the United States will decide this issue by June.
That's a very good question.
Here's our best answer.
You anticipated one I was going to ask.
Well, that's right. We're cutting to the chase.
And what I was going to ask as well.
And we're cutting to the chase. Here's why we think you should. Because the United States Supreme Court needs as much input as possible from lower courts on this issue, especially state Supreme Courts, from whom we have not heard much on this issue. This Court, if it decides the issue, and we urge it to, may be one of the last courts to take up these questions before the United States Supreme Court does, and could be a valuable addition to this national conversation over whether the Constitution compels states to adopt and recognize same-sex marriage. Now, for the past 18 months, we have seen an unprecedented wave of decisions declaring unconstitutional the definition of marriage that has been embraced by every state in this nation since the beginning of the nation up until about 10 years ago. At the same time, this has been occurring during a democratic debate on the issue in which citizens have been debating whether to enlarge the definition of marriage to include same-sex couples. Some have, through the democratic process, a minority of states. Most have not. So what does that mean? In our view, it means this. It means these decisions that are declaring unconstitutional the man-woman definition of marriage are not advancing freedom. Instead, they are usurping the democratic authority of state citizens to grapple with what is a novel, difficult, and fundamental question about the meaning of marriage. We respectfully ask this Court to go a different way. The way charted by Judge Feldman in his opinion in Robichaux, and also by Judge Sutton in his opinion for the Sixth Circuit in the DeBoer case, and reaffirmed that our federal Constitution leaves this issue up to the state citizens. In other words, that it doesn't have one right answer to what is a novel, difficult, and brand new issue.
Have any state Supreme Courts ruled squarely on the issue?
Justice Hughes, I'm trying to think. The issues.
Massachusetts did, didn't they not?
Sorry.
Massachusetts did they?
Well, that was in the Goodridge case back in 2003, and that was a state constitutional decision. That wasn't quite the issue here, Justice Weimer. It's before the Arkansas Supreme Court. I do not think they rendered a decision, and I'm not aware of any others. I may be forgetting one, and if I remember it, I'll.
And I know there's several federal appellate decisions. Do we know the total number of judges that made those decisions?
Well, let's see, Your Honor. So we've got the first one to come out was the 10th Circuit. That was a 2-1 decision. The 4th Circuit then came out. That was a 2-1 decision, so we're at 4-2 there. And then you've got the 9th Circuit. That's 3. So, 7-2. And then you've got the 7th Circuit, and that was also 3. So that's 10-2. But then you've got the 6th Circuit, and that was a 2-1. So I've lost count at this point, but we're looking at 11-12.
7-4.
Something like that. And then you've got Judge Feldman's opinion for the Robichaux case. 5th Circuit hasn't decided that yet. It was argued on January the 9th. You've got a district court from Puerto Rico who decided in favor of the states on the Baker issue. So, you've got a number of judges, but very few state Supreme Courts. And the issue's pending before the 11th Circuit as well, and perhaps in the 8th Circuit and the 1st Circuit. But here's the basic point, though. The issues in this case, whether states must recognize a same-sex marriage from another state as a basis for a step-parent adoption, those issues, in our view, cannot be decided without grappling with what Windsor means. Windsor being the United States Supreme Court decision from 2013. Now, we think there are 3 points in Windsor that ought to decide this case for the states and for the state of Louisiana in this case. What are those 3? First, Windsor reaffirms state authority to define marriage. Windsor said states have the historic and essential authority to define marriage. That is why Windsor struck down DOMA Section 3. It was not because DOMA Section 3 simply discriminated against on the basis of sexual orientation. It was because, as the court said, DOMA Section 3 interfered with state sovereign choices about who may be married. It put a thumb on the scales of how states choose to shape their marriage laws. State authority is one. Second, same-sex marriage is a brand new phenomenon. Justice Kennedy in Windsor said same-sex marriage involves a new insight, a new perspective on marriage. And then he went on to say, historically, most people have thought the man-woman aspect of marriage has been essential to the role and the function of marriage throughout history. Now, that's Justice Kennedy writing in Windsor. Same-sex marriage is a new perspective. The man-woman definition has been thought essential. That's two. Three, democratic consensus. Windsor stressed that when the people of New York in 2011 decided to recognize and then adopt same-sex marriage, they engaged in a statewide deliberative process. They talked to each other. They thought about what is marriage, what does equality mean, and they reached a decision on a foundational issue. And what did Windsor say about that? Windsor said that the dynamics of state government in our federal system call for consensus on this issue. Why is that? I think it's common sense. When a state is making the transition from what had been thought essential to what is a new perspective, the state citizens have to carefully consider that as a matter of democracy, as a matter of political accountability. That's who gets to decide this question. And what did Justice Kennedy say in Windsor? He said they engaged in a statewide deliberative process that allowed the citizens to weigh arguments for and against same-sex marriage. And when the people of New York decided to do that, then they conferred what Justice Kennedy called the dignity of marriage on those couples. And what did he do at the end of his opinion? He said DOMA refused to recognize what New York had done, and he limited his opinion and holding, not just the holding, but the opinion, to those lawful marriages. So those 3 points, state authority, the novelty, the new perspective of same-sex marriage, and democratic consensus. What does that mean for the state's case here? Again, 3 things. State authority. We have seen in so many opinions Windsor being cited for the proposition that states cannot retain the traditional definition of marriage. Windsor says just the opposite. It spends 7 pages and 16 paragraphs tracing the authority to define...
Let me ask this,
yes.
Mr. Duncan.
Please.
If we're looking at Windsor, Windsor had to do with the federal estate tax. This couple
Correct.
married in Canada, were living in the state of New York. And I think Windsor says that federal law cannot create 2 tiers of marriage.
Right. Within the same state.
That's right. And so if the federal government allows same-sex couples to have the benefit of the state tax, even recognizing our long history of relegating domestic relations to the states, can the state say, can any of the 50 states or territories say you don't qualify under our state law?
They can, Chief Justice, and here's why. It's because the different sovereigns. What Windsor said is the federal government historically has deferred to what states say about marriage, right? They have deferred, and what DOMA did was unusually depart from that deference and say, we don't care what you did. And as a matter of fact, we want to influence what you do by changing the definition, by enacting a federal definition of marriage. But the opposite is true when a state decides to retain its definition. Because as Windsor said, states have been doing that since the beginning. That is the basic authority in our federal system to make domestic relations laws.
So you're suggesting that Windsor would allow 25 states to recognize same-sex marriage, get the benefit of the state tax, but for those other 25 to keep on doing the things?
Yes, it would, Chief Justice.
And deny couples the estate tax, the federal estate tax?
Not the federal estate tax. That's up to the feds on the federal estate tax.
Okay.
We're talking about state taxation and state benefits. Okay. So the answer is yes, because and we know that to be the case, because Windsor said, while there can't be a 2-tier relationship created by the federal government and state, states may vary on very important things. What did Windsor say? Degree of consanguinity, right? Not every state allows first cousin marriages. And Windsor went out of its way to say states may vary on that. Age. Windsor pointed out that in New Hampshire you can be 13 and be married. Windsor did not suggest that every state had to recognize New Hampshire's marriage. So Windsor said states may vary, but the federal government can't put its thumb on the scales. That's a quote from Windsor. Put its thumb on the scales and influence the states the way the state shapes its marriage laws. It's a basic sovereignty issue. Now, you will hear people say...
Well, before you move off of that,
go ahead.
I agree with you that Windsor certainly leaves open that option for the United States Supreme Court to reach a decision that will allow states to retain the bans. But how do you go farther? You seem to be going farther than that, than to say that Windsor dictates that result. And I don't understand that. I certainly agree Windsor leaves open that possibility, but what is your argument that it dictates?
Well, I don't know if I use the word dictate, Justice Guidry. If I did, that's too strong. But I think the right answer is it's somewhere between dictates and allows. And here's why. Because if the states don't have the authority to decide which way to go on this issue, then Windsor doesn't make any sense. Windsor's deferring to the state of New York's decision and saying you must respect that. Now, if the Constitution compels the states to go one way, then what is Windsor deferring to? It's sort of like a fake decision. It's sort of saying, well, the states can deliberate on this issue, and the states in their exercise their sovereignty can figure out which way they want to go on this issue, but in the end of the day, they can only go one way, right? I don't think that's a plausible reading of Windsor, and I think it takes out the major premise of Windsor. Here's another. Also, people will say, well, yeah, that's part one of Windsor, but part two of Windsor is all about the dignity of same-sex couples and how the state can't do anything to harm the dignity. And the answer to that is the dignity of same-sex couples in Windsor was conferred by the state of New York. And Windsor is saying, when New York did that, the feds cannot interfere with that decision. The dignity came, as Justice Kennedy wrote, from the people of New York getting together and saying, look, we think marriage has a different meaning now. It's been a long evolution for the people of New York, but now it has a different meaning. And so what Windsor said is when they do that, they confer a dignity, and the federal government cannot interfere with it. That is the holding of Windsor. And, I submit that Windsor doesn't make any sense if the states are constitutionally compelled to recognize same-sex marriage, and they can't go any other way. I just don't see how Windsor makes any sense.
You began with Windsor, and I realize it's a very recent expression of the United States Supreme Court, but what about Baker versus Nelson, 1972? It was a same-gender marriage case. It went to the United States Supreme Court from the Michigan Supreme Court on due process and equal protection challenges, and the Supreme Court in a one-line order said the appeal did not raise, quote, substantial federal question. I mean, isn't that the latest expression of the United States Supreme Court on this specific issue?
Well, I agree that it's the latest expression on the specific issue of licensing, right? And so, yes, if this were purely a licensing case, I would feel comfortable saying, look, Baker versus Nelson settles the issue. I guess the problem is that you've got a lot of courts out there who are saying there have been doctrinal developments. Now, we don't agree with them. But the fact of the matter is this is a recognition case. So what we're making a deliberate decision, Justice Weimer, which I think you're putting your finger on. We're not relying on Baker versus Nelson for that reason. This is a recognition case, and there are other precedents from the court that strongly say there's no recognition required. But having said that, here's how we strongly rely on Baker v. Nelson. Baker v. Nelson came 5 years after Loving versus Virginia. And my friends on the other side in this case, and so many courts around this country have been saying the interracial marriage bans in Loving versus Virginia are no different from the traditional marriage definitions in this case. And I've got a lot to say about that, and you've read my brief on it, but the first thing I'd like to say about it is how implausible that is, given that 5 years after Loving, on a court with Thurgood Marshall on it, decided that same-sex marriage doesn't even present a substantial federal question. So it is, with all due respect to these other courts, it is very difficult to understand how Loving could ever stand for that proposition. It simply doesn't. And it also means that Loving cannot stand for the proposition that there is a right to marry, quote, whomever you choose or independent of the characteristics of the person you are marrying. Loving can't possibly stand for that. Loving is about invidious racial discrimination. Loving is about the relics of slavery. And to draw a straight line between Loving and this case is a bridge, 2 or 3 bridges too far. And Baker versus Nelson is just sort of the first point in that. Moving on.
What was Justice Thurgood Marshall agreed with the majority in Baker?
Well, it was, as I recall, it's a per curiam unsigned summary disposition, so he was on the court, so I assume, yes.
You assume he did?
Yes, yes.
Before we get too much more into the merits, or really get into the merits
Sure.
of your argument, let's stick with Windsor for 1 minute. Don't you believe that it is highly likely that the United States Supreme Court is going to obviously revisit Windsor in its addressing of the DeBoer case?
He'll have to say what it means, yes.
Correct.
Right.
And so they will have to revisit it and interpret it and apply it and perhaps distinguish it or not. But it's going to be a big part of that ruling by the United States Supreme Court, which we would expect to be rendered sometime this summer, correct?
End of June. I think that's absolutely right.
All right.
Now, but when the court does that, of course, Windsor, the ink's not dry on it yet. I mean, it's a 2013 opinion, written by Justice Kennedy, who also wrote Lawrence, who also wrote Romer. Windsor, I know you've read it, I've read it many times. It's structured in a deliberate way. Think about how short Windsor would have been had Windsor been recognizing a fundamental right to marry someone of the same sex. It would have been a really short opinion. It would have said you have a fundamental right to marry someone of the same sex, and the federal government just violated the Fifth Amendment. Windsor didn't do that. Windsor said nothing like that. Think about how short a Windsor opinion would have said if classifications on the basis of sexual orientation get heightened scrutiny or even strict scrutiny. It would have been a very short opinion. Windsor said nothing like that. Even the Solicitor General of the United States spent 19 pages of his brief saying apply heightened scrutiny, apply heightened scrutiny. Windsor doesn't say a thing.
It does talk about creating a second tier of marriages, doesn't it?
That's correct.
Where we're going to treat some marriages one way, and then a second tier of marriages where spouses would have fewer rights and choices.
That's correct. That's correct. The feds have to respect what New York did when it decided to confer the dignity of marriage on same-sex couples. The feds can't pick out one group of people from New York and say, you're not going to be the same as the other people who New York allowed to be married. That's correct.
And you don't think Windsor speaks to that prohibition of creating a second tier of marriages in other states?
Well, we don't have that here. We have one tier of marriage in Louisiana. It's the definition that people decided on. In states that adopted same-sex marriage, they have one tier of marriage.
Well, we have, but then we treat other couples differently. We're suggesting.
Well, we treat all sorts of couples differently. We treat unmarried couples differently.
Right.
We treat friends differently. We treat families differently. We treat all sorts of people differently. The question is, to your question, are we creating a two-tiered system of marriage in this state in the way that Windsor condemned? And the answer is clearly no. Because the states have the traditional and historic authority to decide the marital relation. It would simply be inconsistent with
we may be creating a second tier because we're suggesting that there's some couples who come to this state who are legitimately married in other states and their marriages are not recognized here. And then now we're talking about full faith and credit, of course, but because now we're saying there's a second tier of marriages because we've got the ones we recognize, and then there's some that are consummated in other places and legitimized in other places that we fail to recognize. So haven't we created another tier?
Well, again, I don't think so, not in the way that Windsor talks about it. And when we do or do not recognize marriages from other states, Louisiana is exercising the same authority that it's always exercised under the full faith and credit clause when it decides what marriages to recognize and what marriages not to.
And that's how I guess we get to the analogy of Loving against Virginia that I'm familiar with, the biracial couple from Virginia that are married wherever they got married, but they couldn't even travel together to their home state of Virginia because Virginia did not recognize the marriage. So are we treating this married couple, where were they married?
Well, in the Loving case?
California here.
Where was this couple married?
California in this case.
Yeah, so if this couple was married in California, then we may be treating them in the same context as the Loving couple
Well, Virginia would have
Loving.
thrown those people in jail for even coming back to Virginia. I mean, we are worlds away.
We're not as draconian these days. We
we're
don't
nowhere
jail
near
them or
yeah,
shoot
we're
at them
nowhere
or-
near that. Look,
Okay.
to your point about Loving very clearly said the miscegenation law there was a badge of slavery. It was designed to prevent race mixing. It was as odious as it gets, unless you reach back to Plessy versus Ferguson. Okay, now, but consider this. Let me try to answer your question this way, Chief Justice. Imagine if that's true, if not recognizing same-sex marriage is just like invidious racial discrimination. And let's reread Windsor. Now, is it even conceivable that Windsor would have talked about New York's democratic deliberative process in the way that it did, if what New York was doing was deciding whether to sort of climb out of the gutter of invidious racial discrimination? I think that is impossible to imagine. Justice Kennedy did not say, in 2011, New York decided to remedy a constitutional violation that it had perpetuated since the beginning of the nation. What he said is that most people have thought that this man-woman definition of marriage has been essential. There's a new perspective. New York engaged in a deliberative process, and they decided to confer dignity on same-sex people. So it sort of boggles my mind to think that what Windsor is setting up is and by the way, if New York hadn't have done that, it'd be just like the Virginia in Loving versus Virginia. Very, very difficult to understand.
I think we'd be, and which is why I'm assuming it's not as if I can read into the mind of the 9 justices to assume why they granted this case and why they're bringing it up. But can we create a nation where people are married in one state but not married in another, recognize their marriage is a legal entity that's gets full faith and credit in one state, they travel across state lines and get a different result? That's what we tried to do with removing all those vestiges of segregation. We can't have people unable to move around. You get your rights are recognized. You get benefits of all the rights in one state, but then you cross a straight state line and get a different result. How can we do that? We're going to recognize the marriage in California if they travel to Nevada, or if they travel to Louisiana. I guess we're just simply saying you need to stay in the state where the marriage is recognized. I mean, that violates the Commerce Clause, doesn't it?
Well, they're not making a dormant Commerce Clause argument. They're also not making a right to travel argument. But, I mean, to answer your question...
Well, you can't move around America, can you?
Sure you can. But here's the problem.
How can you move around America, take a job opportunity in Louisiana, if your rights are not going to be recognized?
I think this is a question for the political process, and here's why. Because this is a brand new development. 10 years ago, nobody recognized same-sex marriage. Nobody. No state did. Now you have a brand new development. Sure, it's a quick development. A minority of states have recognized it democratically, something like 11 to 14. When you have that happening in our country, does it create problems? Sure, it can create problems. And sure, are you going to have some equilibrium problems? Sure, you're going to. The political system needs to take care of that, right? What doesn't need to happen is for judges to point their fingers at the people of the states who are not advancing as fast as they think they should and say they're racists. I think that's not how to deal with the problem, and I think that would be contrary to what Windsor said about the issue.
Race is not the issue, right?
Well, the plaintiffs in this case have made it all about race. The lower judge, the trial court judge in this case, made it very much about race, and many of the decisions around this country have drawn a direct line.
Well, they're using race as an analogy, but race is not an issue in this case. This is not a mixed race couple.
It's a bad analogy, Your Honor. It's a really bad analogy, and it's a harmful analogy.
Well,
and it's an analogy that shuts down legal analysis instead of trying to say, look, we've got a new development here at a very basic level of understanding about marriage. Frankly, it was going fine. It was proceeding the way that our country wants these things to proceed before the federal courts jumped into it and said, well, it's a constitutional issue. I mean, that's what the Supreme Court did in Roe v. Wade. They stopped democratic deliberation on a very important and sensitive social issue. Justice Ginsburg has said that.
We're not going to talk about abortion today, are we?
Well, I think it is relevant insofar as there you had the judges, the federal judges, sort of saying, look, we're going to stop deliberation on this issue by freezing it in one place. And here you have judges saying, look, we're going to freeze one view of marriage in the Constitution, right? And if you look at, for instance, the Kitchen case in the 10th Circuit, those judges on the Kitchen court came up with their own definition of marriage, right? They said, well, it involves a loving commitment between two people. Well, I mean, that's great. Some people do have that definition of marriage that cuts out the sort of procreative potential of man-woman couples, which has been the whole point of having man-woman marriage since the beginning. So people are entitled to come to a different view about what marriage means. The people of New York did it in 2006 and 2011. But some people don't have that view, and that's why we have 50 states. Now, I commend to your honors the Hernandez opinion. The Hernandez opinion is from the New York Court of Appeals in 2006.
You want to reserve 5 minutes?
I am. Does that mean I'm cutting into my reserve time? Well, I just commend to you the Hernandez case from 2006, and with that, I will sit down. Thank you.
Chief Justice, Your Honors, good afternoon.
Good afternoon.
May it please this honorable court, my name is Josh Guillory. Together with my co-counsel, Professor Paul Byer, we represent Angela Costanza and Chastity Brewer, both individually and also on behalf of their minor child, referred to as NB in these proceedings. I would like to quickly just address the court and say that I will address all issues regarding intra-family adoption, also the relief that we're asking in this case, and my colleague, Professor Byer, will address all constitutional questions that the court may have. I'd also first like to address the question asked by the court, why should you hear this case when we have pending litigation before our highest court? At the heart of this case is a 10-year-old little boy. And I ask this honorable court to please urgently and respectfully ask the court as quickly as possible to make that decision, because it has a direct impact on him and the parents that we represent. And Your Honors, we also submit that the text of Article 1243 of our Children Code, which we believe governs in this case as far as intrafamily adoption, provides a straightforward solution in this matter. All elements in that particular article, just from a textual standpoint, we submit to the court is met in this case. And we also respectfully say that it's met primarily because the state at the trial court level conceded that the marriage between our clients is valid under California law. This makes Angela Costanza the spouse of Chastity Brewer. Whether the state recognizes that, that's an argument I would ask my colleague to make in full faith and credit, and also other constitutional arguments. But from a textual standpoint, Article 1243 is satisfied. And if I may, the three elements. First, there must be a relation between the child and the petitioner by blood, adoption, or affinity. That is met. Angela Costanza is related to this child through affinity, both from its recognition, Your Honors, and also recognition of the marriage in California, but also affinity, closeness. She's been raising this child since he was born, over 10 years. The spouse, Angela Costanza, must also be a spouse and be a joint petitioner of Chastity Brewer. That is met. And also as far as physical custody for more than 6 months, that is, we far exceed 6 months in this matter. And Your Honors, that's the only arguments I have as far as Article 1243 goes, pending your questions.
One quick question.
Yes, Your Honor.
And if you know the answer, you know, and if you don't understand.
Yes, sir.
If this adoption is not recognized, what would happen to the child if the birth mother would pass away? Would the adoptive or the purported adoptive mother have any rights to claim custody of the child?
Not automatically, Your Honor. She would have to petition the court. There are other parties that could infringe on that direct relationship between the child and Angela in this case. And more so, she would be burdened in ways that other parents wouldn't be burdened.
Well, what would happen if a child only had one parent, an unwed mother, and the mother dies? I mean, the law takes,
Sure.
we have
Yes, ma'am.
provisions to take care of this child.
Yes, ma'am, we do. And with that, Your Honors, I'd like to have my colleague, Professor Beyer, address all constitutional issues in this matter. Thank you.
Professor, congratulations. It looks like your former students are now a majority of the court.
Well, I checked. I hope this doesn't count against me. I checked with our registrar, Mr. Justice Creighton. Welcome to the Louisiana Supreme Court. And she said, no, he was not your student. I know you were colleagues. Chief Justice Johnson, if the court please. Mr. Duncan hasn't said a word about adoption. And my colleague Josh Guillory is quite right. What's at stake in this case is a 10-year-old boy, NB, whose best interest should guide your honors in reviewing Judge Edward Rubin's adoption order below. I want to start my argument. I'll respond to what Mr. Duncan has said rather curtly and briefly, but I want to start by reading to your honors an excerpt from a letter, this is in the record, that the principal of NB School sent to Judge Rubin in support of the adoption. This principal knew both Angela Costanza and Chastity Brewer as NB's parents. Her letter adds a human element to what otherwise might be just the dry legal arguments presented. It says this: if their parenting is visible, it is in the beautiful son that they have raised. N stands out as one of the most loving, caring, and supportive boys I've had the privilege of supervising in the 8 years that I was his principal. He stands up for what is right. He stands above the rest in compassion, friendliness, and genuine concern for all around him. And then comes this: he stands up for what is right. I urge your honors to stand up for what is right in this case. To stand up for the sanctity of the family. To stand up for the liberty of marriage and marriage recognition, and to stand up for the equality of an intra-family adoption. Now, here are my remarks listening to my dear friend, my adversary here. We strive mightily, but whatever your honors hold, and whatever the Supreme Court ultimately decides about the basic substantive issue, the freedom of marry, does it extend? Does loving apply by analogy? I assure you that after your judgments, Mr. Duncan and I will continue to eat and drink as friends. Now I'd like to disabuse you of some of his arguments because they're overblown. First, I should say, well, I was shocked to hear Mr. Duncan say that the arguments we're making, these courts that have decided this case in favor of Costanza Brewer, the 10th Circuit, the 4th Circuit, the 4th Circuit, the 7th Circuit, Judge Posner would be shocked to hear that his judgment for the 7th Circuit is not advancing freedom. Liberty and equality do evolve over time. And Mr. Duncan respectfully has forgotten that. What about Judge Feldman's order? I heard a reference to Judge Feldman. Judge Feldman said that Loving versus Virginia has nothing to do with this, that the Equal Protection Clause, it was born of racism. Well, that's plainly wrong. I teach my students that the Supreme Court has broadened the notion of equal protection far beyond race discrimination. And may I suggest to your honors that the Supreme Court has controlled Louisiana's family law. That's Kirchberg against Feenstra. In our civil code, we used to say that the husband is head and master of the community of Acats and Gaines. That went down the equal protection drain. How about Levy versus Louisiana, where as a matter of family law and succession, this state did not allow illegitimates to inherit from their mothers. That too was declared unconstitutional. So now I'll come to Windsor. And again, I want to disabuse you of Mr. Duncan's advocacy that Windsor is the be-all and end-all of this case. Justice Creighton, I think you're quite right to say, well, won't the Supreme Court revisit this whole matter? Exactly. And what I would say is I teach my students to study these opinions with a microscope. It is true that Justice Kennedy emphasizes the sovereign authority of states over their family law to define marriage. He says that. No doubt about it. But he also expressly disclaims the same sovereign authority cannot deny to its citizens their constitutional rights. He says that twice on 2 consecutive pages. And now I have the pleasure of reciting what His Honor Justice Antonin Scalia, who's a favorite of my students and who's a strong intellect. This is what Justice Scalia said about the meaning of Windsor, and he's there. He's in the conference room. After all, in Lawrence v. Texas, which overruled Bowers, and Justice Kennedy wrote Lawrence, Justice Scalia said that, well, the majority is now ready to extend this privilege of privacy to a same-sex couple. He predicted that. What did he say in Windsor? He said this: in my opinion, the view this court will take of state prohibitions of same-sex marriage is indicated beyond mistaking by today's opinion. The majority's limiting assurances, Mr. Duncan quoted the last sentence, this only applies to lawful marriages, will be meaningless in the face of the reservation against state sovereignty of equal protection and liberty. And the majority knows that. And Justice Scalia ends that quotation by saying, that's why the language is there. Each and every one of you are justices on the state Supreme Court. Each and every one of you know that these opinions that you're obliged to follow are not self-defining. In fact, I teach my students that after Windsor, it will be open to the Supreme Court to tell us what it means, Mr. Justice Creighton. We all know that. And there's enough in Windsor. Even Judge Feldman said, well, there's a little for everybody. So it remains to be seen what the Supreme Court of the United States will say about the meaning of liberty in America. And it remains to be seen what the Supreme Court will say about equality in America.
Professor Baer.
Chief Justice Johnson, I'm sorry.
I just want to raise this issue with you because the minority opinions in Windsor, rather than disagreeing with the result reached by the majority, they just seem to say on procedural grounds, we didn't need to reach this issue. That the plaintiffs had relief, the government doesn't oppose it, we didn't even have to take up this question.
I think, Mr. Chief Justice, what you're talking about is Hollingsworth versus Perry.
No, I'm talking about Windsor. I'm wondering, Scalia, it wasn't his position that we didn't need to take up this issue. Isn't that his position basically in Windsor?
In Windsor, Justice Scalia dissented.
He was dissenting.
Yes.
It seemed to me more on procedural grounds.
Well, maybe I'm mistaken, but I read what Justice Scalia said as he was adamantly opposed to the Supreme Court reaching out to declare that the Constitution would condemn what the United States government is doing.
Right.
He's a conservative rock.
He is.
There are judges who are inclined not to interfere with democratic choice. But if you read the circuit courts of appeals who agreed with our position, and there are plenty of them, there are plenty of judges.
He suggests this.
All right.
He says this court is eager, hungry to tell everyone its view of the legal question at the heart of this case, but standing is an obstacle. He says a technicality of little interest to anyone but we the people who created it as a barrier against judges' intrusion. And so I guess I was trying to find that strong position against what the majority was suggesting, that we could not, in this case, create a subset of a second tier of marriages.
I think your observations about second tier are very fine. Let me just respond to what you said about Scalia's opinion, the language. I think Justice Scalia said that the majority in Windsor had no business reaching out to decide this, right, because the majority should govern. It's the argument of restraint. And so he's not in favor of judges overruling the will of the people. And my response to that, and Mr. Duncan has urged that, is what many judges have said. And that is, it goes back to the framing of our Constitution. I mean, what are the Bill of Rights for? What is the 14th Amendment's guarantee about, if not the obligation of judges to enforce these rights? Now, you may disagree about whether there's a right or not, but if you tend to agree that liberty is an evolving concept, and so is equality, and Justice Kennedy has voiced that, that's the way I view it. Maybe one or two of you, or maybe the whole court will view it that way. But Justice Creighton, we're going to find out. I'd like to just say that among all the judges that we've got, I want to just read, this is the Sixth Circuit. This is in DeBoer versus Snyder. I've directed your attention in the brief to what a woman judge, Martha Craig Doherty, said. This is what she said. I subscribe to this. John Marshall is a bust right outside the doors of this court. And here's what Justice Doherty said. If we in the judiciary do not have the authority and indeed the responsibility to stand to right fundamental wrongs left excused by the majority of the electorate, our whole intricate constitutional system of checks and balances, as well as the oaths to which we have sworn, prove to be nothing but shams. Now, I teach judicial review. I teach the role of a court. I have a great respect for certain justices, one of whom is Lewis Powell. Justice Powell said no to the city of East Cleveland when they struck at the heart of Mrs. Inez Moore's family. She was a grandmother. The situation's a little different. She just wanted to retain her grandson in her own home while her son worked. And some of the justices said, well, we don't have any authority to strike down this. That's a regulation of the family. But Justice Powell did. And that's Mrs. Moore against East Cleveland. I think that's a precedent that's important. But the best one of all that's in the brief is what Justice William Brennan said in a case called Smith versus the Organization of Foster Families. This is Justice Brennan. And Judge Rubin recited from the Smith case. And here is what Justice Brennan said. I'm quoting from his opinion. It's a majority opinion. No one would seriously dispute that a deep, loving, and interdependent relationship between an adult and a child in his or her care may exist even in the absence of a blood relationship. But public law has no business incorporating private bias in its law, and that's the case of Paul Moore versus Sidoti. And like Kyle Duncan, I come with notes, you know. So I read it. That's Chief Justice Berger. And we had a state judge who said, I'm not going to permit this to happen because it would be bad for a child to have interracial couple to adopt him. And Paul Moore versus Sidoti. That's 466 U.S. 429. 466 U.S. 429. It's 1984. And the judge, it was a custody case. He said, well, we have a woman, now she's married a black man, and I'm going to deprive her of the custody of her child. Chief Justice Berger said, that will not do. And I thank my colleague for suggesting that case. I've put it in your arms. I think I'm almost done. I've talked about Scalia. What about Schuette? What about Mr. Duncan saying that the Supreme Court said that Michigan can adopt an amendment that prescribes affirmative action? What about Schuette? Well, courts below have said that Schuette does not change the result that Windsor dictates. And that word is in the Fourth Circuit's opinion, and that's Bostick against Schaefer, I believe. So I've talked about Schuette. Let me just add the revenue bulletin issue, which is at stake. I mean, how can Louisiana say that if you're of the same sex, that we're not going to allow you to file a state income tax return? The federal government allows it. And Judge Rubin said that just denies equal protection. I urge you to affirm that. And I'll now reach the full faith and credit clause, because glancing at my notes, that's an important point that I would like to make in response to what Mr. Duncan has said. Chief Justice Johnson, I think you put your finger right on it. because this couple is lawfully married in California, and the state does not contest that marriage. The state says if you cross our state boundary, you are divorced by a matter of state law. And I think, Chief Justice Johnson, you're right, quite right to say, well, that doesn't make any sense. And the purpose of the full faith and credit clause, as the framers put it in the Constitution, was to make a separate collection of sovereign states, one nation. And we are one nation. And Mr. Duncan said that, well, you don't recognize a marriage. You're limited to recognizing judgments. Lo and behold, when I looked up 28 U.S.C. and I actually read the law, what I discovered was that there's 28 U.S.C. section 1739, and it says in bold black ink that states are obliged to give full faith and credit to non-judicial records. And under California law, you get a marriage certificate. If the state solemnizes your union, then your certificate is recorded in the office of the Los Angeles County Recorder, where it is, and it's entitled to full faith and credit throughout the breadth and length of this nation. My time is short, and I must conclude my argument. If your honors please, Josh Guillory and I have tried to argue this case with some degree of objectivity. We've tried to put out of mind as nearly as we can the harms that Louisiana law causes Angela Costanza, her family, with NB as a part of the family. We think it obvious that Angela Costanza and Chastity Brewer know what is best for their child. And the harms are obvious. The affidavits of Angela and Chastity are undisputed. They lay out the consequences of this impairment of their liberty and their equality. And so what I implore you to do is to affirm Judge Rubin, affirm him on grounds that to deny this couple freedom of family, the sanctity of the family is a liberty interest. That's Justice Lewis Powell's expression. So abide that, affirm Judge Rubin's adoption order, and above all else, as you judge this case, please, your honors, consider the best interests of NB, a child of 10 who stands up for what is right.
Thank you, Professor Bayer.
Oh. May it please the Court, I'd like to start in reverse order. Professor Bayer brought up the full faith and credit issue, which I didn't talk about fully before. The basic distinction that is missing here is the distinction between judgments and statutes. That's very clear. The Supreme Court's always said that. Baker versus General Motors is the last time it said it in '98. There's a stark difference between the full faith and credit that is accorded to a judgment versus a statute. There is no case that says that a marriage is a judgment for full faith and credit purposes. None. The statute that implements a full faith and credit clause has never been interpreted differently by the Supreme Court, although they've cited it. It's simply not a part of Supreme Court jurisprudence that there's a different result from the words of the statute versus the words of the Constitution. There is obviously no decision from any court that says full faith and credit is owed to same-sex marriages across state lines. There is also no decision from any court that says first cousin marriages are accorded full faith and credit. States deal with those through comity, meaning they make a democratic decision about their public policies. This court decided a case, it's an early case from the early 20th century called Brinson v. Brinson. I think it was cited in our appeal application, but not in our brief. Brinson v. Brinson involved a bigamous marriage from Mississippi, and this court said exercise the authority of judicial review. The state's not saying that at all. Of course there's judicial review. The question is, judges and justices need a right in order to strike down a statute. They need to tell the people where that right comes from, and there is no such right to same-sex marriage in the United States Constitution. We urge the court to reverse. Thank you very much.
Let me make sure I'm crystal clear on
Sure.
on one point, and then let's go back to the full faith and credit clause argument you made a minute ago. I want to hear just a tad bit more from you regarding the full faith and credit clause demanding exacting credit of another state's judgment versus a public act.
Right. Great.
Can you just elaborate for a minute on that, please?
Sure. So let's take a judgment, and let's take one in the domestic relations area, divorce. Right. Long been a principle of law that since a divorce comes from a judgment of a court, that states owe full faith and credit. They can't relitigate the divorce in their courts and say that the people are not divorced. That's William versus North Carolina. That's Scherer versus Scherer, which plaintiffs cite. Let's take another one that's in the domestic law context. Adoption. Adoption is a judgment of a court. So if the plaintiffs in this case had adopted a child in California, Louisiana would owe full faith and credit to that adoption, which means that Louisiana couldn't relitigate the adoption among the parties. Right? And the Fifth Circuit's already decided that issue. I argued a case, Adar versus Smith. It means that the parties to the case are owed full faith and credit for the judgment. It doesn't mean Louisiana has to change its public records, right? But you get exacting credit because it's a judgment. Now, marriage, I don't understand the plaintiffs to be arguing that marriage is a judgment. Marriage is something that's regulated by statute. It's regulated by the public acts. So if you look at the full faith and credit that is owed to public acts, it is essentially a conflicts of law issue. A state can apply its own statutes in a situation like that if the state has any reasonable contact with the dispute. And here we're talking about domiciliaries wanting to perfect a step-parent adoption in Louisiana. So I don't think it's a stretch at all to say that Louisiana has enough contacts with that dispute to apply its own laws. And that's all that full faith and credit requires. Does that answer your question?
Yes, it does. Thank you.
Thank you.
All right, the matter will be submitted.